Good afternoon. We'll be starting in a minute or so. Thank you for those who've already joined. Wait for the clock to turn 1 minute past and we'll make a start. Well, good afternoon, everyone. Welcome on behalf of Trust Mediation to this lunchtime webinar, the third in our 2026 series. My name's Tim Wallace, and I'm joined today, as you'll see on screen, by my fellow mediators and hosts, Leah Brocklebank and Andrea Barnes. A few housekeeping notes. We'll run for an hour. We are recording the session, and the recording will be available on the Trust Mediation website in a couple of days or so. Please put any questions or observations in the Q&A, which you should have available on your screen, or the chat button, either or. As we go along, we welcome questions, and particularly challenging questions, so please pick up that challenge. Feel free to state your name or remain anonymous when you ask questions. And if I can work the technical aspects of Teams, we have some polls for you today. Final announcement, our next webinars are on 22nd April and 20th May, and the subjects will probably include neutral evaluation and Trust Mediation's new mediators. So today's presentation, if I can just move on from our panel, these are the subjects we're going to cover. We should be looking at good valuations, good choice of ADR, good timing, and some of the costs aspects arising. Emphatically, this is not about teaching grandmothers to suck eggs. It is about some serious research into decision-making when negotiating settlement, which Leah and I introduced in the last webinar. It's about those researchers' suggestions based on their research about improving the quality of decision-making and how that might be done. It's about comparing those suggestions with your practice and considering whether you might use those suggestions when negotiating with an opposite party. Now, to kick off, I'm trying to give us a snapshot of current practice, and I'm going to try and launch a poll, if you'll bear with me for just a moment. Launch poll. Hopefully you'll see a poll on your screen. I've got a lovely message here which says something went wrong, please try again. So I shall do that. But the third time I'm asking, I'm still getting the same response. So I shall abandon that poll, and apologies for that. The dress rehearsal went very well, but then again, it always does, doesn't it? So let's move on and take a look at decisions in practice. We start in the usual way with the full liability valuation set out in a schedule of loss and a counter schedule. The counter schedule, of course, may have caveats if there are issues on liability or causation, but that's the start. We then recognise that there is actually a range of valuations and some litigation risk into account. And so there appears a bracket, the schedule of loss as the upper bracket, but realistically, the claimant's advisors will be advising the claimant there is a lower bracket. In practice, as mediators, we find there are two lower brackets. One is as advised to the other side, and the other is the actual advice to the client. And that is replicated in the usual way, which you will all be familiar with on the defence side, with a lower bracket and a more realistic upper bracket. So that's setting out what we all know and are very familiar with. In mediation, this is what we see. There is usually a gap between claimant's realistic lower bracket at X pounds and the defendant's realistic upper bracket at C pounds. If there is a small gap between C pounds and X pounds, then that matter will probably settle without any thought about ADR at all. It will be picking up the phone, writing a letter, making a Part 36 or something like that. But there is often quite a large gap. Sometimes, as mediators, we see the gap can actually exceed not 6 figures, but exceed 7 figures. And it's not at all unusual for that gap to be very large. And the question arises as to why those gaps exist, why the differences in evaluation, and what other factors come into play. And this leads us on to the research, which, as I say, Leah and I mentioned last time. This is a book written by United States practitioners and researchers, and we'll have a look at what they had to say. And this was about the research carried out in 2008 in the States, as I say, but still of relevance here and still of relevance today, even though that was carried out some time ago. What did they find? Overconfidence bias, self-serving interpretation of evidence, and compounded uncertainty across issues. I'll come to a worked example of that. And essentially, their finding was there was empirical evidence of frequent settlement error. And our finding is that that applies just as much today in the kind of cases we work with. There is a reminder there is a poll working, but I'm not going to try and that a second time, so we'll leave the polls out for today. Moving on to the next slide. The researchers looked at over 2,000 litigated cases, and they defined, when they were carrying out this research, they defined a decision error as where you had rejected a better offer than the trial result. And the finding, 61% of cases were decision errors by plaintiffs, nostalgic to use that word, and 24% fewer decisions made by defendants, but the defendants' errors were financially larger. And they looked at some of the reasons for this and considered how the decision quality could be improved, recognise all of the tangible and intangible costs. Now, I think any litigator worth their salt would be taking into account all of the tangible costs listed there, except perhaps for the enforcement risk, which is sometimes overlooked. And if it is, that can be very costly indeed, as anyone who has done it will testify. The intangible costs listed there, they can be the reasons why a case is going to be settling in the zone that I mentioned, the orange zone before the usual settlement zone at an ADR. And these costs, these intangible costs, are often not fully assessed when looking at all of the risks in the case. So, how can decision quality be improved? The researchers advocated a process of making a thorough assessment of all the risks, and breaking the case down into stages, and at each stage looking at the explicit probabilities, and to multiply sequential risk. That is where a claimant, for example, has to succeed at one barrier and then another and then another. Those are a set of 3 risks, and I'll give you an example of how they need to be multiplied out together. Be realistic on costs and include the non-financial or non-tangible costs, as mentioned. So let's move on to that example. And if we look at this very, very superficially, we have a claim which has got a claim value of 120,000. And the claimants advise that prospects of success on limitation are 85%, on breach 80%, and causation 75%. Very quickly, does that mean that this is a claim where the claimant has got something like an 80% shot at £120,000? The answer is no, and this is a very straightforward worked example. You would ordinarily be doing this in your head, but the purpose of the example is to show that if you actually multiply out those risks against the other, you come up with an answer which is not necessarily intuitive, because if you do multiply those risks, the overall risk is something like 51%, as the calculation there shows. So you're not looking at something like 80% of 120,000, excuse me, you're looking at more like a 51% overall recovery. Now let's go into that one in a little more detail. You've got the claimed damages there, 120, and this works through how, if you do multiply those risks out, you get to something like 51% overall, which equates to 61,000, not 120,000. But what we have done is to look at the claimed damages of 120. Let's assume that, in fact, the advice to the claimant is that the damages range is between 100 and 120. And then drilling down on that, when the claimant asks, well, what chances have I got of getting 100 or 120? How does that work? And the advice is, well, you've got a 25% chance of getting the top figure of 120, a 45% chance of 110, and a 30% chance that it could be as low as 100. Multiplying that out, the probable value of the case is 109,500. So that figure, 109,500, is the figure, not 120, to which you should be applying the risk of the limitation and breaching causation. Applying those risks and multiplying those risks out, you get a probable value of 52,000. And this was the type of thinking which the researchers came to and said that this kind of risk assessment was not necessarily carried out as often as they thought it might be. Now, as I say, this is not teaching grandmother to suck eggs. You may be very familiar with these principles and use them frequently, or you may not, and you may take a look at them. Or you may, in a negotiation, just apply some of this thinking to the figures that are being put to you. It is something which we as mediators do as we explore the orange zone between the claimant's lower bracket and the defendant's upper bracket. That completes part one of our 4 parts, and I'm now going to turn over to Leah and Andy, who are going to talk about choosing the right ADR process.
Thank you, Tim. Good afternoon, everybody. I'm very pleased to be joining you. Andy and I are going to work collaboratively on this section, so I'm hoping I will speak to the right slides, and Andy will join in as well, and vice versa. So a bit of scene setting here for choosing the right ADR process. Lady Chief Justice Carr was speaking at the London International Dispute Week in April 2024, and she said that judges are increasingly likely to be called upon, further to the requirement to manage cases, to consider whether to mandate the use of ADR, and not just to consider the question of whether to do so, but also the broader question of which form of dispute resolution to mandate. She said the parties will need to play their role. They will need to consider constructively and further to the CPR's overriding objective which process might best suit their circumstances, and they will need to inform the court of this view. And as importantly, judges will need to be familiar with the different forms and their features so that they can properly assess which is best suited. So the parties need to consider which form of order, and the judges ought to be considering it too. And so we hope that this bit of this next section will help us bring those thoughts together, I think. So I think that's over to you, Andy.
And on that, I think we've agreed, Tim, Leah, myself and the rest at Trust Mediation, the alternative has really been dropped, because we know under the civil procedure rules, dispute resolution as a spectrum is now considered and it's embraced in the rules. I go back to 2001 when I looked at the White Book, and there was only 2 references to an alternative dispute resolution, and they were arbitration. And now we have over 320 references to a form of dispute resolution as a must, and that litigation is seen as a last resort. What we can see is, looking at that spectrum of dispute resolution, we've got what is traditionally seen, negotiation, and that negotiation model, Part 36. We've got a little bit more formulated joint settlement meetings. But sometimes the participants need a neutral third party to come in and help them with that conversation, and in particular, make it an effective conversation, looking for options to move forwards. Mediation is prime for that. It's something now that has not only taken up speed, but is now endorsed by orders of the court and in case precedent. We've also now got early neutral evaluation. For the first time, NHS Resolution last year have incorporated that as part of their dispute resolution scheme. We've got adjudication. if people do want that preliminary indication and they want that more formality, but without going to trial and the risks involved. You still have arbitration, which is there, and then you have the final point, that last resort court trials, which we know, looking at the reality, there are delays, there is a lack of judicial sitting time, there is a lack of judiciary to hear cases, and there are even delays just in case management to get to that stage.
So I'm just going to look at mediation and JSMs, which is it's a sort of $6 million question, really. And if I can start with the JSM characteristics, it's quite a fast process. It's a flexible structure. The parties agree it when they want to carry out, and they often work. They often reach resolution, and of course the settlement is not binding until it's reached. What we say about JSMs, though, is that it's usually later on in the proceedings, and the parties are often detached from the negotiations. By what I mean is that the claimant, the defendant wouldn't see the claimant, and vice versa, and it's more the legal representatives are more running the show. So whereas a mediation, it's also fast. You need to find the right mediator, perhaps, so that might delay things sometimes. It's Sim, the previous slide, please. Two back. Yeah, this one, thank you. It's you often reach a resolution. Again, it's not binding unless a settlement is reached. Timing a bit different, but it can be at any time, but often it's early in the process or pre-proceedings. And the claimant is at the centre of the discussion. So the claimant can contribute, they can take an active role if they wish, and it's their day, their mediation. And it's, in my experience, is a very safe way for the claimant to be involved. The mediator will accommodate their needs and keep things on track. And then ultimately, we're talking about the orange zone. Well, the mediator will work with the parties to explore the factors that impact on the settlement zone, and work collaboratively to get there. In terms of considering a mediation, so it's quite a structured process, as in we all turn up and sign up for it, etc. You can consider it if there's emotional processing needed, or you need something different, so something a bit more creative, an opportunity for parties to have the voice heard. If the parties are a long way apart, then it's useful to find the reasons for this and explore it, and make sure you fully understand your position, but also the other side's position. It's helpful, as I said, for the claimant to be involved and understand the process, and feel as though they have got something to contribute towards it, and not just being talked at like a spreadsheet. We'd say avoid it if the parties only want a legal opinion, or there's some pressure to settle very quickly. Joint settlement meeting, well, the parties are close to agreement and want some direct communication. So often with the joint settlement meeting, the parties feel they've got to have most of the evidence. So there's been a lot of money spent in getting all that, and they're ready to talk very directly about the strengths of their case. Whereas in a mediation, you may not have all of that evidence between you, you just have enough evidence. We've put here avoid JSM if power imbalances, significant emotional barriers, or likely entrenchment. I was just all going to add there, do you need a neutral there to keep the negotiations on track? Stop somebody leaving, for example, if they get offended by an offer, which can happen at a JSM.
And I would also add, Leah, there's 3 factors I would be putting in place as a checklist for those of you considering mediation or JSM. The first is timing. You are taking people away from something else they would be doing, and they are now caught up in this dispute, whether they are the client, that party, claimant, defendant, the case handler, the insurer, the legal representative, or family or friends coming in support. Because of that, you've got to think about the time that's already been expended. and the time that's future going to be expended if it doesn't resolve. The other factor is costing. A lot of people are doing cost budgeting and cost management, but not really thinking about the real impact of costs in going a particular path and not considering dispute resolution. That can be significant. The final bit is what Tim was talking about this morning, intangible assets, which is that impact emotionally and potentially physically on a person in the disputes. And that can't be underestimated. It doesn't matter if it's the claimant themselves or the insurance or case handler. It can be significant when you're taking their time away from something else they were doing, and it can impact other people around them, employers, colleagues, family, friends as well, whilst the dispute is ongoing. So that checklist should be in mind.
Thanks, Andy. And so just moving on with the characteristics, so obviously a mediation is a confidential and without prejudice process. It's confidential, I would say, in a way that the parties understand it's formalised because they sign the mediation agreement, so they think it's something, well, it is something special. It's a flexible structure controlled by the parties, which again is often of great benefit. It can accommodate breaks, pauses, or it can move quickly. It can be really focused on what the parties need. It's not like a court where the machine just starts and you're in and until the end, or somebody makes a big offer that you want. It's facilitated by an independent neutral, and that keeps the parties from walking away. It keeps it on track. Everyone eventually works together, and again, as I said earlier, it's non-binding unless a settlement is reached, and so it's very, very useful. In terms of why lawyers use it, it can be used earlier in the case. It's more than one stage, allows legal, commercial and practical interests to be addressed together, so bit at a time, and then different ones come to the fore during a mediation. And it's obviously, most of the time parties would hope to resolve the whole dispute, but it can narrow the issues materially so that you can have reached some sort of agreement or understanding, and then move back onto it on another date. So it can be very beneficial. I think that was facilitative and evaluative mediation. This is a question that seems to be asked more and more now. What's the difference? So the traditional mediation is facilitative, I would say, where you've got a mediator managed process helping the parties explore settlement. They don't express a view on the merits. It's kept very neutral. And it's sort of centered on the relationship, communication, confidence in the mediator, as I say, collaboratively building a solution, and that is a good process and works very, very well. Increasingly, some parties would like more of an evaluative process, and that can, at its sort of basic level, can be quite tough testing by the mediator, and draw out between the parties individually the likely strengths and weaknesses of their case or the other case, vice versa. And that's useful when the parties want a firmer reality check on risk and litigation outcomes, and it can be very, very helpful. It's better to know the risks when you're in a consensual process, rather than suddenly realizing something when you spent a lot of money. But what we'd say about it is really the right choice. It depends on the dispute. I mean, you know your clients, the personalities, you know the other side, you know the expectations, and what would work from your client's perspective and your perspective to make the best use of the day.
I would just add to that, Leah, when we're looking at the word personalities involved, it is really important, not just for the parties themselves, but those participating either in facilitative or evaluative, that they have a voice. That's one thing I hear a lot of feedback on. I don't get heard. I don't have a voice at mediation. Now, I've always described mediation as being somewhat akin to Choose Your Own Adventure. Those books that you could read as a child, and you'd read the first 10 pages, you'd come to a crossroads in that book, and it would say, if you want to go to the Temple of Doom, turn to page 10. If you want to go to Leprosy Island, you turn to page 17. Personalities will have a predefined idea of what mediation is. It might be good, it might be bad, or it might be confused. What we try to do in mediation, whether it's facilitative or evaluative, is to be able to guide that person down the path that they're choosing in the book. They're telling us to go to that page, but we do it safely. So even where there's an evaluative element, all we're simply doing is challenging alternative angles, getting them to see other facets to the dispute that might give them a way forward. And the beauty about mediation is it's showing them that there's more than what is defined by the courts or by litigation. It's not predefined remedies. They can choose anything that they see as a way forward, provided it's fair and reasonable to all of the parties concerned.
Well, thanks,
That's really
Andy.
helpful. Yeah, I was going to say, but I think it's a very subjective process, actually, in a way. So it really puts the parties at the centre of it in a way that helps them through it, as it were, which I think is, and as you say, it's very safe. Sorry, Tim.
Sorry, I think this is going to be. I'm finding this an interesting discussion which we're having now, and instinctively, I'm finding personal injury colleagues seem to be drawn towards the evaluative approach, whereas some of the clinical negligence lawyers I deal with, who have got used to facilitated mediation and getting successful results using facilitated mediation, are not so sure. And the view I've heard expressed by them is, look, if you've got a very strong legal team, and the opposing party has also got a strong legal team, do you really want someone parachuting in, as the phrase is used, and who's going to say what's what, when you've been working on the case perhaps as a team for quite a long time and have got some fairly firm views? And so I think this is going to be an interesting debate to play out, whether it's perhaps a case of be careful what you wish for. Do you really want someone coming in and telling you that is why this is the way to go, this is where you should be looking, and so forth? But an interesting debate, and as you said at the outset, Leah, it is something which is going to be discussed by practitioners, by the judges, as the right course of the case is determined. And of course, there's the other subject which we'll move on to now, of neutral evaluation, which is yet a yet further step. Let's have a look at that.
So we have now the option to look at early neutral evaluation. That is where, instead of having the mediator per se coming to the process, you have an independent evaluator who will be given versions of what each party wants to see as a way forward. They will probably set out what their best case is, whether they've got any risks that they perceive, and they ask that independent evaluator to look at an issue or more than one issue and give a non-binding view on the merits. So they might say, having heard all of the information that you provided, this seems to be a sensible way forward. This is very helpful. I've done it for many years in costs where people have got stuck on a particular issue. And I know other colleagues have done it on particular issues where Tim's spoken about things like liability or one issue on causation. To get over that stumbling block, an early neutral evaluation is really beneficial. And then the parties can either then go back and carry on their discussion, or they can look to the more traditional ways of resolving the dispute through negotiation, Part 36, JSM, mediation, and so on. The other way of dealing with it is having an actual more defined period, is going to an arbitrator and having a binding decision on the participants. With that, that's going to be more formal than mediation. It is going to be more akin to going to court, setting out an agenda for that day or those hours that are set aside, putting submissions in, listening to responses, and the arbitrator giving their decision. There might be finality in that the parties don't like, because when someone makes a decision on it, they're saying, well, that's it now, we've had the decision made for us, and some people might be unhappy with that outcome.
And just a further word on neutral evaluation. You mentioned earlier, I think, that NHS Resolution had been looking at this, and I think that there was a pilot carried out, and I think there is a scheme which is still being looked at, but yet to be launched. So we look forward to hearing further news of that with interest. So let's move on to our next slide, Leah.
So this is just to summarise really in choosing the right process. So key decision factors, obviously the nature and complexity of the issues and whether you feel that they're well suited, how much evidence is ready available. So you can mediate potentially with less evidence. You just everyone has to have what they need. They may not need everything and might be persuaded to mediate earlier. What are the client's objectives? What's their appetite for risk, speed, confidentiality, and also proportionality. So whether the likely cost of further process is justified. The costs might be getting too high, and now is a good time to pause. You don't want to get past the point of no return where one side has made their offers and the costs are now too high to move on them. And then whether or not the opponent is or may be genuinely willing to engage, and might a mediator help with that. And I would just say also whether it would be helpful for either party to have the claimants actively involved. It's alluding to Andrea's points about the book and the journey, but often having the parties actually involved in the disputes is really powerful, and it helps them take the time to see what their life might look like when they've settled the claim. So that, I think that's a good one. In terms of timing, so obviously earlier ADR reduces spend. Good to have a meaningful dialogue before the position's hardened, can avoid unnecessary procedural costs. Mediation doesn't have to be once, it can be revisited if the first attempt doesn't resolve everything. You can narrow issues, better understanding of the other side's case, and prepare the ground for a later settlement. And then this is just important to bear in mind that the litigation timetable shouldn't decide everything. So of course you've got to stick to the court calendar if you've got proceedings, but it shouldn't be the sole driver of whether or not and when mediation is explored. In my experience, you often have to think about both at the same time and decide when to sort of but just sort of move up slightly off the track of the court procedure, and when would be a good time to explore mediation, because obviously if that's successful then you'd save a lot of time, effort and money, but obviously it's very helpful to also have the fallback position of the court proceedings, and that's there, and again that's sometimes a powerful settlement driver, when that's one of the alternative outcomes if you don't settle on the day. Thank you.
And just on that one, Leah, the other thing just to sort of factor in is when you're doing cost budgeting, the court will always be more generous on the ADR phase if you are factoring genuinely, I'm looking at all forms of dispute resolution. So you can factor in costs for everything. It used to be traditionally, they didn't factor in mediation under the ADR phase, and now they recognise that is a really important factor to put under there. But they will give you costs for each, the Part 36 offers, the JSM, the mediation, because it's far cheaper to settle at the ADR phase than to go through trial prep and trial itself. The other factor is we've got factoring in for mediation and dispute resolution generally in the fixed cost regimes under the fast track and the intermediate track. So it's something you can actually take advantage of. And it's one of the areas where the courts will justify going outside the fixed costs if you're able to spend more money, as Leah said, going back and revisiting mediation, and the matter settles. The court is more likely to say that was a reasonable feature of the dispute and settling it. As I said, Leah said timing is a really important factor. You've got to look at the indicators and the types of areas of dispute and when they're likely to be best helped by mediation. Liability, where it's broadly clear That's quite good when they know there's going to be some admissions of breach or it's been admitted in full. The parties then can focus just on valuation, added value that you don't get from the court, such as apology or changes in a system, practical resolution rather than just pure thought. So that is an area which would be prime for mediation. Costs becoming disproportionate. It's one thing I would say right at the beginning and throughout any case management of a matter, but even those people who are litigants in person should be factoring in, how much is this costing me, not only financially, but mentally and physically, because it's an impact of taking your time away from doing something else. And it's putting those costs into context with the duration of the litigation. So at the pre-issue stage, when you get to post-issue, but before case management, when you get to case management and you're looking to move those directions through to trial, there should be checking points to see where are we at on those costs and how does it versus maybe looking at some form of dispute resolution.
Thanks,
We
Andy.
can. Yeah.
Sorry for my trigger finger on the slide there.
That's okay.
Very
No.
quickly.
It's over to Leah now, onto the factors to think about.
Thank you. Yeah. So, I mean, this is just sort of more to follow on from what Andy's saying, really. So, has liability been admitted or contested? If it's contested, what are the nature of the issues, and will they need to be tackled at the mediation? Same for causation. Really important is there sufficient information to safely allow the valuation. That's really within the claimant's team's domain. They've got to advise appropriate settlement parameters. That it's easier for insurers because they've got other cases, I would suggest, but what we would say is not a trial bundle because there's really no need for that. Has a claim been issued? Pointer here that most of our cases are pre-issue, less than 50% mediations. Is that more than 50%?
More than.
Yeah, that's the other right. Have the parties incurred significant costs? So pre-CCMC, more than 60% of our mediations are then. And then this is sort of alluding back to Andy's points. Are the claimant and defendant ready legally, financially and emotionally for a serious discussion? I mean, I'd say I often feel that claimants they're on that journey during the course of a mediation, and sometimes it's with defendants as well. But when it's their one claim, they're still on the journey during the mediation, and you can see it's happening before your eyes. Are the parties ready to explore the usual settlement zone is an obvious one. And just one point on Tim's amazing calculations on risk. Obviously, you can run those calculations with the defendant's figures and slightly different risk as well. And it's quite interesting that the zone's not a mile off, probably, even if you run it with different figures. And then obviously no one size fits all. It's bespoke, this, you choose. Each option involves trade-offs and timing. It depends on your own client's objectives. So it is a sort of subjective process, actually. The more I think about it, it's not objective at all. It's a subjective process that the parties can make work. So.
And one thing I would just add to that, Leah, is the NHS resolution report last year. In July, they indicated 83% of clinical claims are now resolving without the issue of court proceedings. The figures before that, which they have for 2022, 2023, were 80%. So it is going up each year. They've also reduced the legal proceedings generally from 34% in 2022 to 17% last year of being issued. That is absolutely significant to just bear in mind, thinking about the broad spectrum of claims that come through on clinical disputes.
I think, Andy, that also raises the question of what evidence you need to settle a case. And sometimes you hear, well, it's far too early, we can't possibly consider settlement at this stage. And in fact, when you sit down with skilled advisors, you most certainly can. And very often in the mediations we see pre-issue, there is further evidence which would be obtained were the matter to proceed. But again, with skilled and experienced advice on both sides, parties can be advised of where the case is likely to go, where the settlement area is likely to be, and settlement can be achieved. Most claims given the choice would be opt to settle that stage rather than saying, oh yes, please go and get the further evidence, please let's take another 6 or 12 or 24 or 24 months. So I think there is an interest on from both sides of the fence on the earlier settlement, and as you say, that is being borne out in the figures. So let's move on. Final thoughts on the process.
Yep.
Andy, I think you're going to deal with
Yeah,
this.
it is. Yeah. So what we know is I'm taking the A off. I don't think there is an A anymore. The A is dead now because we know that dispute resolution is now incorporated in the civil procedure rules. It's something now that they will now advocate for pre-issue. It's in all of the pre-action protocols. The courts have their own pilots in place for certain areas, such as landlord and tenant, the small claims track, some of the fast track, some of the technical courts. And we can see that that's just going to simply grow. We know because of Churchill and Merthyr Tydfil that the courts are now putting orders which state that a form of dispute resolution must be considered. I think certainly from when I do case management, there is certainly more thought now into the ADR phase and not simply looking to do without prejudice roundtable discussions or Part 36. There is actually more power in going to JSM or to mediation. Now you have the additional option to go to evaluation or early neutral evaluation, but you can still structure what that looks like and still retain your client's voice. Mediation, we would say, is going to be the best balance because it offers so much more than the court-defined remedies. It has flexibility, it has confidentiality, and you've got pragmatism in the fact that the parties can agree what's fair and reasonable to them without one particular person feeling that they are the loser. The timing will be dependent, as Leah said and Tim have said, subjectively on the particular case and the personalities involved and the person's predefined ideas of what dispute resolution looks like but means to them. And we're here to be able to assist throughout the life of any of these claims. We're here in the inquiry stage to help with that administration or that checklist. So, Tim, it's over to you.
Thanks, Andy. Well,
Tim, sorry, can I just add one thing,
please.
Which is that I think mediation, I've written that as a more human process or humane process, because after 35 years of acting on the defence side, when someone's future is laid out in spreadsheets and calculations about how many hours of care they need at night, but actually this is a more humane process because the claimant gets some control of it, and it's not as bad as sitting in a JSM where they really aren't participating. They get to be part of it. So I would suggest that we mustn't forget that. It's a good reminder of what this is all about. Sorry,
thanks, Linda. That's very, very helpful, and it kind of brings the picture of mediation into our discussion. That is what is happening at mediation. You're dealing with real people, and it always strikes me at a mediation where you get see a settlement on the day, which we usually do. The palpable relief in the claimant's room that this is over. That's the word I hear time and time again. It's over, and it means so much to them. And their involvement on the day is often a component of reaching that settlement. Well, we discussed this. That's the end of part 2, because we had 4 parts altogether. But the part 1 and part 2 were the big parts of looking at the better decisions on valuation, better decisions on risk analysis. We've then looked at the decisions on the right process and the right timing of process. A lot of decisions to make in ADR. But let's now move on to part 3, Andy, and look at looking backwards. What do we find are the reasons why ADR can sometimes stall or disappoint?
Yeah, I mean, this is something that we can all talk through from our personal experience, Leah, Tim, myself, and other TM mediators. The first thing we see is that suboptimal preparation, getting there on the day after, maybe days or weeks of arranging the mediation, and then being told a document isn't available or a report hasn't been commissioned, and actually that report or that document is pivotal to discussing ways forward. The timing, a knee-jerk reaction because of a court's case management timetable, or because somebody has sent that letter saying we are going to suggest or recommend ADR, and if you don't, you will be cost penalised. A very robust letter, more setting out the punishment rather than the benefits of mediation. So coming in when neither party is really equipped to actually have an effective conversation. Suboptimal choice of process. Tim and I and Leah, we get people frequently saying, well, isn't mediation very much similar to having somebody telling us what the strengths and weaknesses are? And that preconceived idea that mediation is, to a certain extent, evaluative, when actually, as mediators, we just umpire the administration, the process. We are what I would call ghosts in the machinery, gently helping that conversation along so that the participants have a very safe, confidential environment to talk effectively where communication may have broken down. Sometimes by saying, I go straight to evaluation or neutral evaluation or some other form such as JSM or arbitration, they lose their voice and they lose their choice, and therefore mediation won't work. Not appreciating that settlement might involve more than a firm opinion on either the liability which is in dispute, the causation or quantum, or as I found in some mediations, actual capacity. Something in the mediation was that whether that's the right person there to make that decision. Are they the decision maker? Not appreciating that listening with an open mind and being able to change your initial stance is often the best way forward to finding an option for resolution. Very much, and we see it, we get feedback throughout mediation and in the feedback after mediation. Parties feel constrained by their pleadings, whether it's the letter of claim, the letter of notification, the letter of response, the actual pleadings themselves, that particulars of claim or defence. They feel somewhat that they're going to lose a face or embarrassment if they concede something that's already been argued. And we try to impress that, well, mediation isn't about that. It's about you taking a different path. You don't have to take the predefined paths you believe are available. Settlement definitely will not be achieved unless the parties have already done that checklist I talked about earlier, those intangible costs to you, the actual financial costs to date and likely in the future, the timing, where your time is being taken away from and being focused on that dispute, and that means other matters maybe are not getting the time that they should. And that impact emotionally and physically on the people involved. It's not just the claimant and the defendant. Many people get affected. I've heard insurers not sleeping at night. I've heard medical professionals feeling they can't move on. Claimants, where they feel they haven't had a point to grieve about their injury or grieve about the loss of a loved one. So there's a lot of factors going on there which might affect it. Tim said, it may be because there's a big gap between the claimant and the defendant on how they've approached risk, valuation, and so on. But it's maybe not thinking about what factors are there to have as an effective conversation on the day, which will ultimately make mediation fail. I know, Tim and Leah, you've got other thoughts about this as well.
Certainly, I would just add that sometimes a mediation doesn't achieve a settlement on the day, and that is the right result for the parties. So although the discussions may have stalled and there may be some disappointment that we didn't get a settlement today, in fact, the parties have done their work well, the negotiations have gone well and revealed a final gap which can't be bridged. And that gap is there because the parties' assessment is if they can't settle at the region of X and Y, then trial is the right result. And in that case, mediation has done its job. And looking back at the decisions we've been talking about today, if you've made good and defensible decisions and can say, well, those decisions were correct, And yes, we have listened with an open mind, and yes, we have taken into account what we've learned, but this is still, on our assessment, the right decision is to go to trial with this matter. Mediation has done its job, and usually, not only does it affirmed your decision, but it has demonstrated that the real crunch issues, which are going to be the crunch issues at trial, and so your trial preparation can be far more focused, because you know the fighting ground, you know you what got to prepare for. So those are some of the things that I would add on that. But I think that list there that does set it out. And if we get if there are good decisions made on the subjects we've been talking about, then settlement is likely to result, but won't always happen. Just want to move on from that, if I may, and just to say that we, as many of you will know, because we've been advertising the ADR Champion scheme for some time, our view is that if an internal ADR Champion is appointed, that person can be in touch with us and vice versa. And some of the matters which we've kind of skinned over today, going back to the decision trees and those calculations, for example, we've got quite a lot of good ADR material which we think can be of assistance to you in terms of training. So in a way, it's a trainer approach. In a way, it's asking the ADR Champion to let us know when you want us to come in for training, which we're happy to do. So if you think there's some food for thought here, which is of interest to your practice, and you haven't already signed up for ADR Champions, then please don't hesitate to do so. We would very much welcome that. I'm going to pause there and to see whether there are any questions. I'm keeping an eye on the chat and the Q&A, and none have appeared so far. But does anyone have any questions they'd like to put to us? Any observations on what has been said today? And I see there are none. We are a little ahead of time. My apologies for the technical expertise, because I'm sure it's operator error on the polls, which I'd carefully prepared, but we will sort that out for next time. And just to say, to go and to remind you, the dates of the next webinars are there. They'll be advertised in due course, and the recording will be available as I've mentioned. Including on the recording will be this note about ADR Champions, which I mentioned, and how that works. So there being no questions, I'd just like to say thank you very much indeed once again for your time and attention, and hope to see you next month. And if this is of interest, or you think it may be of interest in your firm or organisation, please pass the word that the recording is available. Thank you. Goodbye.
Thank you.
Thank you.